The risk of being apprehended while in possession of illegal firearms and ammunition outweighs the consequences, and the risk of being apprehended for use of your licensed firearm after it has been seized by the Firearm Licensing Authority is also a matter of concern. These issues and others were being debated in a parliamentary committee reviewing the new Firearms Act. The last sitting was on Tuesday. Anna K. Simpson reports on some interesting points highlighted by the members.
Government Senator Shireen Golding Campbell is suggesting that persons whose firearms have been seized be shielded from prosecution should the weapon later be used in a crime.
What is the objection to protecting a licensed firearm holder from having to go through that process if in fact he has handed and surrendered his firearm to the authority? Are we therefore saying that if something happens and that firearm goes on the street and causes some havoc on the street, that that person must now be held to defend himself, even though he has surrendered his firearm to the FLA? I find that a little unfair.
Minister of Legal and Constitutional Affairs, Marlene Malahou-Fort, responded.
You would save and accept that we wouldn't be legislating it in the law, but you would have it under the common law, naturally.
And that's the point I'm making.
Yeah, but you can't. But we can't have the cake and eat it, you know. Because there is no guarantee. While you can guarantee that you may not commit an offense, there is no guarantee that you may not be charged with the commission of an offense. And that is why due process says that if you're charged, you go through the process where the evidence is put, you have an opportunity to present your defense, etc., etc.
National Security Minister Dr. Horace Chang also emphasized that it is unlikely that a person be charged if proper investigations are done.
If the man surrenders his firearm, I'm not charging him if it's come to a firearm. I'm not charging him. Nobody can charge him if the firearm is used in a felony. He cannot be charged. There's no basis to charge him. The firearm is in the Firearms Authority. However, when the police investigate, if he's found to be part of it, he has to be charged. But he can't be charged before that. If the investigation leads to him or whoever it leads to, whether it is the chairman of the FLA, the executive director, investigator, officer, or somebody else, and the owner, then they are charged.
Opposition Senator Peter Bunting insisted that the police should be mandated to give receipts to persons when they seize their licensed firearms.
In all these cases where a constable takes possession of a firearm, not necessarily arresting the person, but takes possession of the firearm, can we have that some receipt is given
that's expected. That's
to oblige them to give some? I mean, I don't want to say we expect it, but to oblige them to give some receipt.
They must give them some receipt,
and in a standard form type of receipt.
Mrs. Malahou-Fort agreed, noting that apart from benefiting the individual, this process would ensure record keeping on the side of the institution. The Firearms Prohibition, Restriction and Regulation Act 2022 was tabled in the House of Representatives on February 10, introducing harsher penalties for the offenses connected to the illicit trade, manufacture, stockpiling, possession, and use of illegal guns. Reporting for the news on PBC Jamaica, I am Anna K. Simpson.